And that appears to be what's happening here. The recklessness falls on the person who didn't die. And that's not how the law is supposed to work. A person is required under the law to yield the right of way, regardless. And I didn't go through the whole soliloquy with Mr. Wright that I did in the previous trial, but I tried to get him 100 different ways to agree with me that failing to yield the right of way was not the cause of an accident because the other person was going too fast. And Officer Wisby said the same thing. She has written lots and lots of tickets for failing to yield the right of way. And everybody always says, well, the other person was speeding. They still get a ticket because they are still the cause of the accident. Here, he was speeding. He was cited for going too fast, I believe. But the actual end result for recklessness purposes is he was not the cause of this accident. The vehicle failing to yield the right of way is the cause of the accident. Mr. Fletcher's speed certainly contributed to it, and they wouldn't have been in the same spot at the same time. But as a practical matter, in terms of following the law, the Honda failed to yield the right of way, and that was their requirement, being at that stop sign. And so his recklessness is not the cause of this death in this case. And so for those purposes, and I would say the same thing is true for the negligent homicide as well. Again, you know the difference between the two. I don't need to go through the whole litany with you, but here again, we can have a jury trial about all of these issues and let a jury decide that. But for the purposes of this court's decision here today, there's certainly not evidence that he was recklessly causing the death. And that's what it would have to be. His recklessness needs to cause the death. And that's not what happened here. It's the failure to yield the right of way is what caused the death here. And that's unfortunate for the family and for everyone involved. It's a terrible tragedy for everyone involved. And I'm not trying to belittle that, but we have to be realistic. And the state has to, I would argue, take a consistent position about these cases. And they're not doing that here. And for that reason, we object, and we ask the court to either find those things not true or hold them in abeyance and let us have a trial on these issues, and let a jury decide with his presumption of innocence. Let a jury decide these issues, Judge. Thank you.
So obviously I was inclined to hear this case, the motion first, which is somewhat rare. Typically we'll have trials first, and I allow the state to go forward this way. At this point, well, a couple of things. There was no evidence with regard to the testing of the alleged marijuana. I don't know if there was testing, if there would be at some further. There hasn't been. I looked back, just as I said, I took judicial notice of the court's files. So I went back in the motion to revoke case, and there was a motion to revoke that was filed back in 2024, 3, something like that. There was a hearing, it looks like, potentially. And at that point, the state, not Mr. Coleman, but the state over in drug court dismissed that motion to revoke based on that motion to revoke had the two allegations, the unlawful carrying and the possession of marijuana.
I'm sorry to interrupt the court, Judge, but I've got authority case law that says that an officer can prove up or substantiate marijuana based on his or her training experience alone. The smell of marijuana and the odor, and I'm happy to provide that case law to the court.
That would surprise me if that was now. I would love to see it, because then I will take a break to read it. But I mean, it's pretty specific now that there are different types and different levels, and some are legal and some are not legal. And as far as
all right, this is a fascinating legal moment. The prosecutor is basically saying that an officer's training and experience alone can identify marijuana without lab testing, but the judge immediately pushes back in. That's huge. In modern drug law, especially with hemp and legal cannabis in some places, Smell alone often isn't enough anymore. So here's the question for you watching. Should an officer's experience be enough evidence in court, or should every suspected drug be lab tested first? Drop your thoughts in the comments because this debate is happening in courts all over the country. Interview and hear.
I know there's nothing that can be trained by smell or look as to whether or not that marijuana is legal or illegal.
And if I may add, Judge, the defendant himself said it was.
I understand, but as in any, look, here's the thing. Do I think it was marijuana? Yes, I think it was marijuana. I think Mr. Fletcher was probably dealing marijuana. That's my opinion. I am constrained by the legal definitions of marijuana and what the testing shows on all drugs. He can think he has cocaine and it turns out to be baking soda, and he would not be guilty of possession of cocaine, even if he thought it was. That's my understanding of the drug laws. And I think that's the problem, and probably why back then there was a dismissal of that motion to revoke filed in drug court that specifically stated, let me find it. It was checked off, why it's dismissed. And that was back on October 16th of 2023. And the mark that was checked off was the evidence is insufficient. So I don't know if there wasn't testing done on the marijuana. I think the testing is required, even as a preponderance. I have notes here. He admitted it was weed. The officer believes it was weed. It clearly was probably weed. Probably weed doesn't get me where I need to be. So I'm saying this for everyone because it's very frustrating for me, because I do believe probably that it was marijuana and that it was illegal, and that Mr. Fletcher was selling it, distributing it, and I mean, you don't have scales and you don't have baggies, and you don't have all those things, and you don't have a firearm. But for purposes of this hearing, I don't believe I can find that count true based on the evidence presented today. So unfortunately, I am going to find counts 4 and 5 not true based on that today. Now, with regard to counts 1, 2, and 3, obviously this is somewhat a, I don't know, I want to call it a battle of the experts or whatever. I don't see how the speed that Mr. Fletcher was going did not have.
Here's the big takeaway from the judge. Instead of rushing to a decision based on limited testimony, the court is pressing pause and sending the case to a full jury trial. That's a major moment because juries get to hear all the evidence, not just the snapshot presented in this hearing. It also means the questions about speeding, right-of-way, and causation aren't settled yet. One key issue remains. Was the speeding driver actually responsible for the death, or did the failure to yield cause everything? That's exactly the kind of complex question juries are meant to decide.
Obviously some cause and causation in this wreck. Also, there was no testimony that said all the testimony that we heard today was that there was in fact a failure to yield, which is extremely unfortunate. And I think what I am inclined to do, and what I was probably already inclined to do before Mr. Gertz mentioned it, is hold off on making a finding in counts 1, 2, or 3. I think all of that probably needs more hashing out, more evidence than what a short hearing would give. Obviously, a jury, or even me, if it were a full-on bench trial where it was beyond a reasonable doubt. I'm not inclined to make that decision based on a preponderance of the evidence because of the conflicting evidence and things like that. So what I intend to do is I'm going to hold this motion in abeyance. We do not have a current trial setting, but I will get one very quickly. The case will be tried. A jury will determine whether or not Mr. Fletcher did in fact commit the offense of manslaughter, the lesser offense of criminally negligent homicide, and or the aggravated assault with a deadly weapon. I think that's probably the better and more fair way to do it for everyone. I don't want anybody to feel like they wasted their time today. But based on the evidence that I heard today, which I would not have known had we not had this hearing, kind of wouldn't have known how to go proceed. So I would say we know that now. I'm going to hold the matter in abeyance. I am not going to make a finding on counts 1, 2, or 3. I'm going to hold making any finding. And then we will see what happens with that trial. That's not to say either that after a trial, even if a jury finds Mr. Fletcher not guilty of those offenses, that with further information that I believe I could legally take into consideration at a trial, I could still find these matters true, some, all, or none of them, after that hearing, based on the evidence I've heard today and the additional evidence that I'll hear at trial. So the motion's not gone. There's still that possibility. But I think legally and in all fairness to everyone, that's the proper way to handle this matter. I will get with Ms. Holmes today. Again, we will get a trial date extremely quickly as we possibly can. I know everyone is suffering and needs some closure to this. I apologize that you're not getting closure today. You likely would not have anyway, because the cases, no matter what I would have done today, are still going to go to trial. So let's get that part taken care of, and then I will conclude the motion to revoke matter at the conclusion of the trials in the other cases. All right. All right. I do want to thank everybody for being here. I know this is extremely difficult, and sorry for what everyone's going through and for your losses and all of that. Mr. Coleman, did you have something else?
Move to withdraw the exhibits, Your Honor, so that they maybe use the trial.
Yes, sir. I will allow you to withdraw all of those exhibits. And again, we'll get a trial set as quickly as we possibly can. I'll look at some weeks, maybe even when we don't already have trials, so that it could be specially set if necessary. I know there'll be several witnesses. And so I'll let you guys know as soon as we have that set. All right.